Good morning or good afternoon, depending on where you are joining us from today. Welcome to today's webinar. My name is Nancy Barnes. I'm a partner at Thompson, Hine and head of the Labor and Employment Practice Group. I am located in the Cleveland office, and I'm delighted to introduce three of my colleagues who are joining me for this presentation today. Also here in Cleveland is Matt Kissling, who is an associate in our Labor and Employment Group. And from our Cincinnati office, we will hear from Scott Young, who is a partner in Labor and Employment, and Beth Mandel, who is an associate in our Employee Benefits Group. For the next hour to 90 minutes, we will be reviewing the latest developments that companies and organizations are facing, including an array of executive orders and potential directives affecting employers and government contractors. We will review government contracting requirements, potential vaccination and testing mandates, OSHA requirements, and related issues that impact benefit plans. I will begin with a brief overview of a recent survey that we conducted with our clients and contacts. We received nearly 250 responses from employers regarding many of the topics that we will be discussing today. Due to the large audience that we have on this call and the amount of content that we are presenting, we may only have a short time for question and answer at the end of our presentation. We encourage you to put your questions in the question or chat box, and we will address them with whatever time is remaining. Please contact your Thompson Hine lawyer with any follow-up questions that you may have after today's webinar. To proactively answer a question we receive during every webinar, yes, this is being recorded, and we will send the recording and presentation slides to all of the registrants, usually within a couple of business days. Thank you for your interest, and now I will begin the webinar. So very quickly, just to go over our agenda of the topics that we're going to be covering today. First of all, welcome. Secondly, talking through the summary of the survey results from the survey that Thompson Hine conducted over the past couple of weeks just before Labor Day. So just to be clear, that survey was conducted prior to President Biden's announcement. So I'm sure the results of it would be quite different today, but just to give you some historical perspective, we'll talk a little bit about what we found there. We will also be outlining the Biden plan and some of the legal challenges and practical questions that are being raised and that we are having our clients call us about quite frequently. We will be talking about the OSHA-related issues and concerns. We'll be covering the COVID-19 safety protocols and impacts for federal contractors. And we will also be talking about ERISA, HIPAA, and wellness program considerations as a result of President Biden's announcement. And again, at the end, we will be trying to address the questions that are posed to us through the question or chat box. We will get to as many of those as possible at the end of the presentation. So very quickly, I just want to go through some high-level information from the survey that we conducted to share with you what we're hearing from some of your colleagues, different types of industries, different types of employers. So we had about 240 respondents. We actually had a broad array of employers of all different sizes, geographic scope, and industries. So we had employers who were under 50 employees. We had employers who were over 2,500 employees. Some who were regional in nature, some located here in the United States, some with global operations. So really a wide array of different employers, different industries, different employment groups, different demographics that they were dealing with. Again, just an important point, the survey was closed before the Biden plan was announced, and so therefore it does not reflect anything that may have changed as a result of that. And it was not a scientific survey. It's really just a way for us to gather information from our clients about what other people are thinking about and what they're doing in their workplaces. So just some quick information. When it comes to mandatory vaccination, based on our survey results, of the respondents, 6% at that time were requiring mandatory vaccination, and 10% were in the process of planning to implement a mandatory vaccination policy. When addressing whether or not to have a mandatory vaccination policy, the biggest concerns that respondents identified really dealt with sort of employee reaction to that. So issues related to retention, employee morale, recruitment, and then another significant response related to legal liability. And we're going to talk a little bit about that in the context of the Biden plan in a few slides. Another thing that we asked our respondents was about accommodation issues and what sorts of things they either anticipated or were already dealing with when it came to accommodation requests. Not surprisingly, there were concerns about potential religious or ADA related accommodation requests, with some of the respondents already receiving those sorts of requests for accommodations and trying to work through those issues. We're going to talk a little bit about that as well. And then finally, when asked what was the biggest or most important reason that their employees were sharing with them for non-vaccination, personal and political beliefs was by far the most common response, with 44% saying those who were not vaccinated in their workplace, that was the reason why they were not vaccinated. So vaccination status, this is something that we're going to talk about too in relationship to the Biden plan. In terms of reporting, respondents said 21% of them require employees to report their vaccination status. 35% of them encourage it. Another 32% require absolutely no reporting, and 10% are finding out vaccination status as a result of an anonymous survey. And again, you can see below on this slide, in terms of the percentage of workforce vaccinated, really varies significantly, with 18% having over 80%, 8% having under 40%. And in my discussions with my clients anecdotally, a lot of this seems to be very much driven by the location of the employee and the type of workforce that you're dealing with exempt employees tending to be in a higher percentage vaccination status, employees who are in a manufacturing or production role, blue collar type workers tending to be in the lower percentages of vaccination, and that may be something that you need to consider as we go forward. So biggest concerns that were identified in the survey related to the questions that we were asking, which related to vaccination, accommodation issues, masking, social distancing, some work from home questions. The biggest concerns that were raised by respondents were workforce retention and recruitment in this job market. That's probably not a surprise to anybody who's on this call. Questions about, and this is certainly something that we're wrestling with, what does it mean to have fully vaccinated status? A few months ago, we all knew what the answer to that was in terms of the number of doses of each vaccine, or the single dose of Johnson & Johnson. What does that mean now with boosters? How, are you fully vaccinated if you're 2 weeks away from being eligible for a booster? If a booster becomes recommended, what if you miss it and it's a month later and you still haven't gotten your booster? How is that going to impact whether someone is quote unquote fully vaccinated? So that's an open question and something that people are thinking through. Testing requirements, we're getting a ton of questions about that now, just sort of the practicalities of, if we want to test, if we require testing, how are we going to do that? Who's paying for it? Do people have to be paid while they're driving to CVS to go get their test? Should we be doing it on site? So there's a ton of questions related to that. Verification of vac status, people are asking questions about, what can we see in order to determine someone's vaccination status? How do we know it's real and not a fake document? So questions about that. Tracking and documentation, obviously, as we start talking about maybe ramped up testing requirements for employees, taking care of all of the documentation related to those requirements, major headache for employers who have a lot of employees who may need to be tested. Lot of concerns about masking policies, people being disgruntled in the workplace, particularly for employers who may have different masking requirements for employees who are vaccinated and those who are not. So that's certainly something people are continuing to wrestle with. And then just ongoing concerns with the Delta variant, and you can add the Mu variant and whatever the next variant is that I'm sure is coming. Just concerns about dealing with the virus as it continues to mutate. Let's see here. So now the next question is, we're going to talk a little bit about the Biden plan. Just do a really quick overview. I'm assuming that probably everybody who decided to sign on for this webinar knows a little bit of something about what Biden has proposed, but just very quickly, there are 6 pillars to the Biden plan. Vaccinate the unvaccinated, further protect those who are vaccinated, keep schools open, increase testing and require masking, protect our economic recovery, and improve care for those with COVID-19. So as we go through some of the implications for employers, we're largely going to be focused on the vaccination prong, protecting those who are vaccinated, and the increase in testing and requiring masking. Those are the things that are probably most on the minds of employers and those who advise employers. Okay, so from a timing perspective, this is probably the most common question that we get. You know, when is this happening? When is this going to be issued? It is unclear. I would say at the initial press conference, there was some suggestion that the OSHA standard would come out this week. Since that time, there have been interviews with the Department of Labor, which suggests that it's coming in the coming weeks, which would suggest not this week, but maybe in a couple of weeks. It could certainly be longer. So there's no set deadline for the OSHA standard to be issued. But you know, to sort of be thinking about it coming in the next 2 to 3 weeks and doing whatever planning you need to do in that regard, probably a prudent course of action. It could be longer, and if you have longer, that's only going to help you. When it comes to the Safer Federal Workforce Task Force issues, that guidance is set to come out September 24th, 2021. Questions about when will these things be effective, how will they be enforced, etc. No clear guidance on that. Scott's going to talk a little bit about the way OSHA standards work and timing, etc. So we'll touch a little bit on that. Legal challenges. Okay, a lot of people have questions about, you know, even when this gets issued, is this something that is actually even going to go into effect? There's, you know, press conferences and politicians talking about different entities who are going to sue and stop these various things from going into effect. Some of the things that are a question mark are whether or not OSHA has jurisdiction to do all of the things that President Biden suggested that may be part of their order. So we'll have to see about that. There are questions about whether or not it meets the administrative rulemaking requirements. And so there could be sort of that administrative regulatory process could come into question. You know, a lot of people are talking about whether the federal government can mandate vaccinations and that's going to be challenged. We've already seen challenges to hospital system putting vaccination requirements in place, the university putting vaccination requirements in place. Those things have been upheld. So the mandatory vax has been upheld, subject to the exceptions you're probably aware of: religious, ADA, disability, etc. So, you know, from our perspective, I would anticipate that whatever vaccination requirement is put in place, that the challenge is not going to come simply from that, and I don't think that challenge is going to be upheld. There could also be challenges from sort of like a state government perspective. Certain governors have said that they're going to challenge this. Most legal scholars who are looking at the basis for those challenges don't think that those are really going to stand up, so that's probably not going to be an issue. But there will be lawsuits, no question. And then the injunctions, this is something, I'm not going to get into a law review article with everybody here on the phone, but there are questions from a legal perspective about whether a district court judge in a particular district has the authority to issue a nationwide injunction. We have seen these in the context of FLSA disputes, and various other rulemaking over the past probably 4 to 8 years. We have seen some nationwide injunctions, so it's certainly possible, but any injunction that is issued by a district court would immediately go up to the Court of Appeals and potentially to the Supreme Court for a very quick review as to whether or not that injunction is going to be in place to prevent the implementation of the rule while it's being, sort of litigated on the merits. So we will have to see about that. Okay, so let me go to my next slide. Okay. What we don't know, and I hate to have this webinar and tell you all the things that we don't know, but so we're not going to be able to provide you with any insights. We haven't hacked into the Department of Labor, so some of these things we just don't know yet. The actual terms of what OSHA is going to put out, we do not know. We have some decent guesses based on what has happened previously. And so the presentation today is going to be giving you our best thoughts on that, but we don't know the actual text of what's going to be issued. As we talked about effective dates and timing for that, we don't have answers on that, although we have some, some predictions. The penalties and enforcement, we can talk about certainly what is provided for under OSHA, but how that's going to be enforced. For example, how is it going to potentially impact remote workers? Because that's something that OSHA typically doesn't get into, people who are working from home. So, but we can't say for sure what's going to be included in that standard. How to count employees. For those of you who feel like you're kind of close to that 100 employee threshold, this may be a very important question for you as to whether you're included or excluded. Is it based on the corporate entity? Is it the entire parent organization? Is it a particular location? And who is an employee? Is it a part-time employee? Is it a temporary employee? Is it a contractor? Who's going to be included when you are counting up, 100 people? So if you are close to the threshold, depending on how you skin that cat, that may be something that is extremely important to you and will be something you focus on as soon as that is issued. Okay, some issues to consider just as you are planning for what may be on the horizon. There certainly may be policy changes that you are thinking about or that you may need to implement when it comes to, again, vaccination status, reporting that, vaccination, mandatory vaccination, exceptions to that, testing requirements, what you're paying for in terms of people going to get the vaccine, people having side effects from being vaccinated, people spending time getting tested on their way into work. So there may be a number of policy changes and communications that you need to think about. Vaccination status and inquiry. This is something that I, from a recommendation standpoint, this is something I would suggest to you. It would be prudent to get your arms around. Where do you currently stand with your employees in terms of 90% of your people are vaccinated, 25% of your people are not vaccinated? Where do you stand? Because that is going to probably have a significant impact on what is going to be feasible for you in terms of both mandatory vaccination or implementing a testing program, or what the costs of a, the wages for having to implement something and pay people to undertake those activities. I mean, these are all things that if you don't know what percentage of your workforce is already vaccinated, it's going to be harder to quantify that. So that's certainly something that you can do in this interim period, is get your arms around that. If you're thinking about a testing strategy, starting to think through how is that going to work in terms of, would it be on site? Would you have people go to a particular provider to have the testing done? Are you going to pay people? How are you going to track it and manage, the documentation of that? How long, are they taking a test where they get an instant result? Are they taking a test that takes 2 days to get the result? Are you going to stagger that? If so, how are you going to do that? So those are all things that you could, even if you're not putting a strategy in place yet, at least be starting to think about those issues and how it would work for your particular workforce. Document tracking and management, huge nightmare. Definitely something you want to start thinking about, and having the people who would be responsible for making sure that those things are kept in a confidential and private way, starting to think through those processes, thinking through the accommodations process. This is certainly something that, for those who have implemented some sort of mandatory vaccination policy, have gotten a lot of requests for accommodations, and thinking through how you're going to handle that, having forms in place to document that, potentially updating your job descriptions, because if you go through an accommodations process where somebody says, for whatever reason they cannot be vaccinated, and it's a valid religious or ADA type thing, having a job description which clearly outlines whether or not that person actually needs to be in your workplace and why, that might be a good thing to do in advance of having these accommodations where suddenly you have a lot of people for ADA or religious reasons can't be vaccinated, and you're making the decision they can't be in the workplace. What does that mean? Are they performing an essential function of their job if they're not in the workplace? Wage and hour issues, as we touched on, how are you paying non-exempt people who maybe have to go and go for testing? How are you handling PTO? How are you handling quarantine issues? So those are all things that you can be thinking about. If you're in a union environment, bargaining and talking to your unions about issues and things, policies that you may be putting in place when it comes to vaccination, certainly something that would be good to start thinking through. And then finally, are you a government contractor or a subcontractor? Sometimes people are surprised to find out that they actually fall into those categories, and Matt's going to talk a little bit about which contractors are subject to the executive orders and give you some insights on that. So now I will turn it over to Scott Young, who's in our Cincinnati office, who's going to talk a bit about the OSHA related issues.
Yes, hello. Good afternoon, everybody. Next slide, please. Yeah, so I'm going to take a slightly deeper dive in terms of issues as I see them from that part of the announcement last week by President Biden with respect to what he indicated OSHA would be issuing last week. It was going to come out this week, but as Nancy indicated, based upon some interviews with the Department of Labor this week, they have indicated that they're not prepared to put anything out this week, but it will probably come out in a few weeks. And so it is from that vantage point. The other part that I'll talk about a bit is in August 13, OSHA did issue at that point an emergency temporary standard that did impact, and it's pretty specific in terms of the healthcare industry. There was at that same time, on August 13, they also issued guidance for the general industry. There was certainly some talk at that time as to, well, why didn't you issue a standard then for the general industry in the same manner that you did for the health? And so that's what we do know is what President Biden said last week in terms of what he expects to be in this emergency or announced will be in this ETS standard. What we don't know for sure is whether or not it will cover some of the other things that were in the guidance that came out by OSHA mid-August. So from last week, what President Biden said was that the OSHA would be developing a rule that would require all employers with 100 or more employees to ensure their workforce is fully vaccinated, or will require any workers who remain unvaccinated to produce a negative test result on at least a weekly basis before coming to work. Why is that relevant? And I'll get into that in some of the other slides. But it's one thing if OSHA issues guidance. It's one thing if OSHA, or rather the CDC, puts something out. But those are not generally finable offenses if you do not comply. And so that's sort of the added rub if you have an emergency temporary standard, is because suddenly it becomes a law, and a very specific law. Next slide. The other aspect that's apparently going to be addressed in the OSHA and emergency temporary standard is, in order to ensure that no worker loses a dollar of pay because they get vaccinated, OSHA's ETS will require employers with more than 100 employees to provide paid time off for the time it takes for the workers to get vaccinated or to recover if they are under the weather post-vaccination. And I'll tell you, I have a lot of experience with OSHA standards and dealing with OSHA on a whole variety of matters. And the issue of paying time off, I mean, that's not a typical something that you would see in an OSHA standard. I mean, they do have requirements in terms of who pays for safety equipment, that sort of thing. But this is definitely a bit unique. Next slide. So in terms of questions, and again, we don't have, at the time that we sent out the invite last week that we were going to do this webinar this week, and I think we initially sent it out last Friday. At that point, the announcement was that we might have an ETS standard by now. And so that's part of why, as Nancy mentioned, we're raising more questions as opposed to providing answers, because the developments from earlier this week is it may be a bit longer, and it certainly hasn't come out as of today. So the first question, or one question to consider with respect to this, is how does the new ETS standard, because eventually we do expect it will come out, how is it going to be applied to employees who contend they are unable to be vaccinated because of a medical condition? And certainly sort of a common issue that most of us have run into is, if you're going to require a vaccine, there's the ADA requirements, the interplay. Certainly, if it becomes an OSHA ETS standard, the level of importance to be vaccinated or present the negative test certainly goes up. And so that's that in terms of weighing on that scale. And so that's certainly a question that will need to be addressed. How is the proposed new ETS standard to be applied to employees who contend they are unable to be vaccinated because of a sincerely held religious belief? Certainly, you also have the weekly vaccine that could be done, but that's certainly going to come into play, because certainly the current status is you can require tests, you can require vaccination, or you can require neither of the above. And so in that case, you don't get into the ADA inquiries or the religious accommodation inquiries. But this will be much more in the forefront with this ETS standard. Who pays the cost associated with the vaccine? Certainly and who's going to have to pay the cost associated with the negative test or the testing result. In terms of application of it, as Nancy touched upon, how is the 100 employee threshold going to be determined? Is that going to be based upon the employer everywhere, based upon the location, the total of all locations? Also, how is employee going to be defined? In the normal context, it is defined based upon who the W-2 employee is, but OSHA does have these joint employer concepts, and so we'll have to look for that definition to see if they throw staffing agency employees and those individuals that may be regularly at your workforce but are not technically your W-2 employee to be considered as part of that threshold. Next slide. In the context of a unionized workforce, as Nancy pointed out, with a collective bargaining agreement, when this ETS standard comes out, obviously there's going to be changes in terms of the terms and conditions of employment with your unionized workforce. And so with respect to that, you have to deal with, okay, do you go the route of mandatory vaccine? Do you go the either or and just sort of go with the OSHA standard? But you also have to consider I guess we skipped a slide. Why don't we why don't we go to the third slide, go to that, and we'll back up. With respect to the unionized workforce, how do you implement it, the requirements of the new ETS, and how do you gauge violations, and how do you handle that? As Nancy also talked about with respect to the OSHA ETS and being subject to the legal challenge, the general rule with that is in order for OSHA to have an emergency temporary standard, they have to show or demonstrate that there is grave danger to the health and safety of the workforce if they don't implement it and that it's necessary. And so if there is a challenge, that is what OSHA would be put to the test for. And so that the argument is that is why back in August, OSHA issued the standard very specific that it did with the healthcare industry and got a little less specific with respect to general industry. But that looks like that's going to come to the forefront. Contract to benefit implications, what does that mean? Certainly from the government contract standpoint, Matt is going to talk about that and Beth is going to talk about the benefit. Let's go to the prior slide. Yeah. Another question from looking at in terms of the language of the OSHA ETS is that when it requires an employer to pay an employee for time off while under the weather caused by an employer mandated vaccine, is that covered by workers' comp? Is that direct pay? Is that covered by your paid time off policy, or is that going to be something subject completely different? If it's direct pay, are you going to get tax rebates? I mean, a lot of those things are not answered. And then with respect to under the weather, what does that mean? I think that's something that we're going to be looking at from that vantage point, because certainly, are they meaning a couple of days of feeling a bit groggy and fatigue, or are we talking about, it doesn't happen very often, but what about the individual that may have a serious complication from the vaccine? I mean, is that subject to the PTO off? Is that a duration? That's just question sort of issue spot to think about in terms of sort of realizing that the announcement from last week actually raises a whole lot of questions and certainly explains why we haven't seen any OSHA ETS as of today. If an employer does not mandate the COVID vaccine, but rather requires either the weekly negative COVID test or the vaccine, does that still mean that the employer is required to pay the employee for time off if the employee elects to be vaccinated, and then for the adverse effects? And the reason why I make that distinction is if it's employee choice, then the argument could be, well, we're not requiring it, so how are we having to pay this individual as compensable work time for this? And that again, we expect will be something that will potentially be addressed, hopefully, certainly in the OSHA emergency standard or through later guidance. But that is the question that I wanted to highlight for you from that vantage point. Let's go to skip to the next slide. That one. And so this slide outlines, okay, well, what if I just decide, I'm not going to require this. What are they going to do about it? There are a lot of employers. We're not going, how are they going to enforce it? What does that mean to my business? The issue is if OSHA issues this as an emergency temporary standard, you certainly could take the tact that, look, I think it's unenforceable, and if that's the way the wind blows, in terms of attorney generals around the country challenging it, you could decide to take your chances. But just knowing how it often works in civilly is if OSHA comes out with a standard or a regulation, that is generally considered a standard of care for the business. And so that means that if you operate a business and your business exposes third parties to the people that work at your business, and OSHA has a standard that if you are an employee at this business, then you either were a negative test for COVID or you've been vaccinated, and that turns out not to be the case, you certainly open yourself up to potential third-party actions, particularly given that the qualified immunity that was rolled out a year and a half ago is ending at the end of September, unless it's extended. So that's just something, certainly in Ohio and in other states. So that's something to consider. Then also, you have to deal with OSHA itself, and if you decide not to comply, and somebody calls you out on it, their potential OSHA whistleblower claims, OSHA regulatory violations, and monetary penalties. I mean, technically, a willful violation of an OSHA standard can lead to up to $134,000 fine per reg. And so, whereas before many of these things that may be under the emergency temporary standard might have been a catch-all under a general duty clause standard under OSHA, if it's specific, then you have to worry about complying with every little subpart. The workers' comp liability as well, because generally speaking, for purposes of COVID and COVID exposures, because it's a pandemic, the general rule in Ohio and around the country is, as long as your employment setting is as safe as other employment settings generally and the public in general, then even if you have an employee that contracts COVID-19 in your workforce, that would be a defense to it. But certainly if OSHA's got a standard and you don't comply, that makes that much more of a difficult defense. The employer intentional tort is an obvious one as well. Wage and hour, ADA, and other considerations are other issues for the COVID liability exposures and how you handle it. Next slide. What I want to touch base with on the next few slides that I've got in the next few minutes that I have with you is just to go over sort of the bullet points of the August 13, 2021 guidance. And I raise this from a bullet point standpoint because these are bullet points that we may find in the new standards. So I don't know that, but there's certainly a possibility that could occur. And so it's particularly a reason to be, I guess, understanding of what OSHA is telling general and industry employers to do effective August 13. August 13, their words with respect to employees is they should facilitate employees getting vaccinated. And they further indicate that employers should, but it's not required in the guidance, should pay for the employees to get the vaccine and pay for their time off. It's a should, not required, but it's just sort of a big red flag that, okay, that's in the should in the August 13 guidance, and look at what President Biden announced last week. Certainly there is the instruct the unvaccinated workers who have had close contact with someone who's tested positive to stay home and quarantine. And that will certainly probably or maybe in the ETS standard. We'll have to wait and see. But that's certainly what OSHA is saying right now. Implement physical distancing in all communal work areas for unvaccinated and otherwise at risk workers. That's the social distancing that most of us are all very aware of. That's certainly something else that we might see in the ETS standard specifically. Next paragraph or next slide. Provide workers with face coverings or surgical masks as appropriate unless their work task requires a respirator or other PPE. Certainly right now, under the August 13 guidance, if you've got unvaccinated with vaccinated, then everybody's supposed to wear a face covering. Or rather, certainly the unvaccinated are. There's certainly a question as to how that will be addressed with respect to the ETS standard. Educating and training workers on your COVID-19 policies and procedures, that could be further in the ETS standard. I raise that as an issue. Certainly California has one that is very specific on point with respect to that, and that's part of the California OSHA standard, and it's on the books. So we may see that in the federal standard as well. Is the ETS standard going to require the unvaccinated customers and visitors to wear face coverings? Right now, it suggests the ETS standard might address that. Next slide. The OSHA August 13 guidance also talks about maintaining ventilation systems, performing routine cleaning and disinfection, certainly the recording and reporting of COVID infections and deaths, that's certainly covered under other standards, but it may be further incorporated, of course, within the potential new ETS. Implement protections from retaliation and set up anonymous processes for workers to voice concerns. That's something that would be in the existing standards, but it's in the August 13 guidance. So certainly wanted to make sure that everyone is aware of that OSHA's doubling down on that. And then next slide. And then my final slide on this is simply, these are some of the standards that currently apply. Even with the COVID pandemic, we would expect quite possibly that some of this might go into further detail on the respiratory protection and sanitation and protection from bloodborne pathogens, similar to what they have in the ETS standard for the healthcare workers, that we may find that in the emergency temporary standard for the general industry as well. And that covers my topic. And Matt is going to talk next about government contracts.
Thank you very much, Scott. So for the next several minutes, I'm going to be speaking to you about another executive order that was issued last week from President Biden, specifically related to COVID-19 safety protocols and government contractors. So this portion of the webinar today may be of interest to you if you currently hold a federal contract, if you do business with a company that holds a federal contract, or if you don't know if you're a federal contractor or subcontractor. Next slide. Okay, so on September 9th of this year, President Biden issued an executive order on ensuring adequate COVID safety protocols for federal contractors. What this is going to do is it's going to impose mandatory COVID-19 safety protocols for certain covered government contractors and their subcontractors. And it applies to any new contracts or subcontracts entered into on or after October 15th, 2021. Now, if you're familiar with the government contracting space, a lot of the unique requirements that contractors are subject to come through executive order. And the reason they do that is the administration really considers it to be the price of doing business with the federal government. Some other recent examples that we've seen have been specific minimum wages, federal paid sick leave, as well as affirmative action and equal opportunity compliance. The vast majority of those obligations all started through an executive order and that went through the normal government regulatory process. So we expect that these new COVID-19 safety protocols, it may go on a similar track in order to go into effect. Next slide, please. So the big question is who's covered? There are really four key categories of companies that may be covered by these new obligations. First, if you hold a procurement contract, or as the government likes to call it, a contract-like instrument for services, construction, or leases. So a contract-like instrument is essentially any agreement between two parties that creates legally enforceable obligations. So they don't need to take any particular form. If it can be considered a contract and it falls within this category, then it's going to qualify for potential coverage. Second category are service contracts or instruments that are covered by the Service Contract Act, which if you're involved in this space, you know that also implicates prevailing wage and certain fringe benefit obligations, as well as federal paid sick leave requirements. The third category are contracts or contract-like instruments for concessions for the federal government. So if you're an example could be if you're providing cafeteria, food services, or concessions to the government, that's likely a contract that would fall within that category. Then the last category of covered contracts are those that are related to offering services on federal property or in national parks. Next slide. So if you fall within one of those four categories, you may be covered if you have a new contract that's entered into on or after October 15th of this year. If you have an existing contract that was signed before that date, but it's renewed or extended on or after October 15th, or if you have an existing contract that has an option that was exercised on or after October 15th. So if all of your potentially covered contracts are from earlier this year or from last year, and they're not up for renewal or extension in the near future, these may be some obligations that you're going to have some time to prepare for before they become required. The other key thing to remember here is that this coverage would also extend to any subcontracts under the qualifying agreement with the government. And those are subcontracts of any tier. So it could even go down to the 4th, 5th, or 6th chain in the process. As long as it relates back to the qualifying contract, the government's going to consider those subcontractors to be covered as well. Next slide. So that begs the question, who is not covered? So the important thing to remember here is, according to the language of the executive order as it's currently written, contracts for the sale or provision of goods to the federal government are not covered by these new COVID-19 safety requirements. That's a pretty interesting exclusion from the executive order, considering the Biden administration had an overall announcement that if you want to do business with the federal government, you need to follow these requirements. So excluding this large category of contracts from the obligations is pretty interesting. Another category that's not covered are federal grants. So if your funding is solely through a federal grant program administered by the government, then you'll most likely not be covered by this either. The one exception to that would be if you're a healthcare organization, you receive Medicare or Medicaid funds. There is a separate requirement that's been issued by the Biden administration that applies specifically to healthcare institutions. So when you compare those two together, organizations that receive Medicare or Medicaid or in healthcare will most likely still have to implement the vaccine mandates that the Biden administration has set forth. Another category that's excluded are contracts or subcontracts whose value is equal to or less than what's called the simplified acquisition threshold in the federal acquisition regulation. Here it's currently $250,000. So if you have an otherwise covered contract and it's for less than $250,000, this is most likely something you're not going to have to worry about at this time. And finally, similar to the first exclusion above, they exclude any subcontracts that are solely for the provision of products. So even if you're providing products to a company that is itself required to undertake these COVID-19 safety protocols, if all you're doing are providing widgets or paper towels or something along those lines, you'll most likely not need to worry about the COVID-19 safety protocols that the government's rolling out for contractors. Next slide. So that creates the next question. Okay, if you are covered, what are the specific safety requirements? Well, it starts, according to the administration, with the language of any new contractor extension, where the executive order requires contracting agencies to enter a new clause into contracts that say, for the duration of the contract, a contractor or subcontractor will comply with all guidance for your workplace locations that are published by the Safer Federal Workforce Task Force. As Nancy indicated earlier, that task force is currently scheduled to issue formal guidance by September 24th of 2021. And then contractors will be required to implement those guidelines for any workplace locations where work is performed in connection with the covered contract. So as you can imagine, the phrase workplace locations is pretty broad, and I'll touch upon it in a few slides as to what that may involve in addition to physical facilities of a covered company. Next slide. So what exactly is the Safer Federal Workforce Task Force? If you recall, this was one of the first executive actions that President Biden took after being sworn in, and it's comprised of really a three-tiered leadership. First, the White House COVID-19 response team. Second, the General Services Administration. And third, the Office of Personnel Management. These last two organizations are really the key organizations that make the government run on a daily basis. And then other members of the task force are the CDC, FEMA, the Secret Service, the Office of Management and Budget, and the Department of Veterans Affairs. So in terms of the guidance itself, what can we actually expect here? So again, the guidance has not been issued. It's due to be released on September 24th, but must still go through an approval process by the Director of the Office of Management and Budget. So at this point, it's really like shaking the magic 8 ball. We don't know specifically what is going to be included, but we do have, reading through the tea leaves, some expectations of what will likely be part of the requirements. And the first and foremost is the employee vaccination mandate. And the reason we believe that's going to be included is when he issued the executive order, President Biden said the following: if you want to work with the federal government and do business with us, get vaccinated. if you want to do business with the federal government, vaccinate your workforce. So that's a pretty clear indication of the direction that this guidance is likely headed, given the pronouncements from the administration. I think it's also worth noting that President Biden has also instituted a vaccination mandate for federal employees, and so it makes sense to expect that they would take a similar approach for employees of companies that do business with the government and maybe around federal employees and performing those services. The other likely components for the guidance would be testing, screening, and contact tracing programs or protocols. So really requiring contractors to put pen to paper and come up with formal programs and procedures for each of these items. And then finally, we expect there to be some level of procedures for face masks, at employer workspaces, social distancing requirements, cleaning and sanitation, and other engineering controls, as well as specific policies related to visitors, where if you have visitors coming to one of your facilities, you may treat things differently than you otherwise would where you have a fully vaccinated workforce at the facility itself. Next slide. So again, the guidance itself is still pending. It hasn't been issued. So, it's really, we're waiting to see, what it's going to look like over the next couple of weeks. But, if you think that you're going to be covered by these new mandates, what are some steps you can take to prepare? First, you should evaluate it if you may be a federal contractor or subcontractor subject to the new requirements. So some of the key questions to ask yourself here are, do you hold a federal government contract? Do you provide services to a third party that has a federal government contract or subcontract? If your answer to either of those questions are yes, what type of contract is it? Are you providing services? Are you providing products? Are you doing something else? Are you planning to bid on a new government contract or subcontract in the foreseeable future? And if you have existing contracts on the books, when are those agreements up for renewal or extension? Are there any potential options that could be exercised on or after October 15th? Next slide. Next, we recommend that you really assess your workforce and look at who is actually performing the government-related work and where is it being performed. This goes back to my discussion previously about contractors being required to implement these protocols for any workplace locations where the government work is being performed. Again, the executive order does not specifically define what they mean by a workplace location, but it does reference that it's any place where an individual is working on the government contracting project. So based on that language alone, this could include remote work and remote employees. If they're at home, but they're performing services in support of the government contract, the executive order as currently written could require them to be vaccinated or otherwise subject to the COVID-19 safety protocols. So that's just something to think about, how this would impact your remote workers if you have them. The third thing to consider are really some more of the logistical issues related to a vaccine mandate if that were to be included in the guidance. First, compensation and paid leave requirements. If you're already covered by these new obligations, if you're a Service Contract Act contractor or a Davis-Bacon construction contractor, you know that you have federal paid sick leave obligations. Requiring employees to get vaccinated could be a situation where they'd be able to take that federal paid sick leave. That's something you then need to track and make sure it's being considered and approved. Another thing to think about is, are you in a state that has its own COVID-19 vaccine leave laws on the books, such as New York, and I believe California has something similar. Again, this would be a situation where if your employees are required to be vaccinated, you need to make sure that you're providing them the necessary paid leave. And on the flip side of the coin, if you're not in one of the states, but you're requiring employees to be vaccinated, the time they spend going to get vaccine could be considered hours worked if they're a non-exempt employee. So those are all things, from a compensation, wage, and hour perspective, you would need to consider. The other thing to consider would be the proof of vaccination procedures. Again, we've already touched upon this in the other portions here today. But what procedures do you have in place for receiving proof of vaccination? Who's going to be authorized to obtain and retain that documentation, and what privacy and confidentiality procedures are you going to have in place to make sure that that information is not being otherwise distributed to employees? And finally, reasonable accommodation issues. Again, we've touched upon this already. The ADA and Title VII for disability and religious beliefs still apply regardless of any sort of a mandate for government contractors. So even if you are required to have your employees vaccinated or otherwise impose other COVID-19 safety protocols, you would still need to consider potential reasonable accommodations for disability or religious belief. So with that kind of wraps it up, the current overview for government contractors. Again, we'll know more in the coming weeks as we get closer to the guidance being issued. But now I'm going to hand it over to Beth Mandel, who's going to touch upon ERISA, HIPAA, and wellness program considerations.
Hi, everyone. So I know all of you are probably thinking, we have enough on our plate. How can we possibly handle all of the benefits compliance issues as well? But unfortunately, this likely will impact a few benefits issues, and we'll go through those and hopefully be able to help you work out your compliance programming. So next slide, please. With respect to employee benefits, I think the key here is that this mandate is likely going to result in employers having to potentially pay to some degree for vaccination or testing, or provide vaccination or testing to employees outside of the group health plan. So we know that you have been already underneath your group health plans paying for vaccination, paying for testing in certain situations. The things that we'll look at today are, does the expansion of the provisions of those types of services result in having to consider additional ERISA, COBRA, HIPAA compliance concerns? Will you have additional plan documentation issues that you have to deal with? Will you potentially have HIPAA privacy and security issues that you'll have to deal with in either collecting or accessing information related to vaccination or testing? Next slide, please. So as I mentioned, employers who sponsor group health plans have already been paying for COVID vaccination and testing to some degree. With respect to testing, the FFCRA and CARES Act requires most group health plans to provide full coverage of COVID-19 testing and then certain related items and services. However, that applies when testing is performed for diagnostic purposes. We did get guidance from the IRS that indicates that requirement, the FFCRA and CARES Act requirement, did not apply to testing for general workplace and health and safety purposes. So likely, to the extent testing has been done for workplace health and safety compliance, that's been done outside of potentially the group health plan coverage. Vaccines, with respect to coverage of vaccination, non-grandfathered group health plans must cover the cost of the vaccine and administration of the vaccine. But as we know, not all of your employees are going to be covered by your group health plan. So then we'll get into questions of, will you have to expand potentially coverage of vaccine? Next slide, please. So if you are paying for vaccines or testing outside of your ERISA group health plan, or if you are contracting with a third party to potentially, for example, come on site and provide vaccines and testing, then you are potentially creating a separate group health benefit plan. So unfortunately, or however you want to look at this, medical care is defined very broadly under ERISA, COBRA, HIPAA. In general, it includes anything that's provided, any amounts paid for the diagnosis, cure, mitigation, treatment, or prevention of disease, or for the purpose of affecting any structure or function of the body. So in general, we would consider that to likely include vaccinations and COVID testing, done for the purpose of mitigating or diagnosing a disease. And if you are providing services related to those types of medical care, or if you're paying for that type of medical care, then you're likely creating a benefit plan that is governed by ERISA. Now, in some cases, we've seen employers who offered like one-off vaccination events, where maybe on a Monday morning or a Saturday, they had someone come on site, offer vaccines, and people could come and get vaccinated at their employer's work site. In those cases, we've seen some employers take the position that that's not a benefit plan because it's a one-off event. There's no real administrative scheme. Anybody who comes can get the vaccine. And in those cases, you're probably, there's a reasonable argument that you are not creating a separate benefit plan. But if it turns out, and we think it may, that employers are going to be in a position of having to pay for testing on a weekly basis for employees who are not vaccinated, then it's more likely you're tipping over into a group health plan at that point. So issues to consider once you've created this separate group health plan. Nancy, next slide. All right, so actually I'm going to skip over this given time. Next slide, please. I already talked about that. So paying for vaccination and testing, you might be subject to ERISA requirements, which include written plan document requirements, a requirement to maintain and distribute a summary plan description to employees, Form 5500 filing requirements. There are also COBRA requirements that apply to group health benefits with respect to coverage continuation after qualifying events. There are HIPAA requirements, including non-discrimination requirements under HIPAA, and additionally privacy and security requirements. And then there are ACA considerations. Next slide. So options for addressing ERISA. Luckily, you do have several options. You could maintain the testing benefit as a separate plan, which would involve creating a new plan document, filing a separate 5500, creating a new SPD. That option is probably not going to be attractive to most employers. So instead, what we've seen is that employers are generally trying to integrate the testing program with a current benefit program, or create a new benefit program that is wrapped into a current welfare wrap plan. So that would involve amending the current plan document, recording the benefit on your current Form 5500 rather than filing a separate 5500, and then revising any current SPD to just include information about the new benefit program, or creating some sort of separate SPD related to the benefit program that can be distributed. Next slide. All right, COBRA. COBRA is kind of interesting because you think, if we're going to be providing testing for purposes of workplace safety, do we really need to provide COBRA to individuals after they've had a qualifying event like termination of employment? Well, unfortunately, according to the strict letter of the law, probably yes, you do need to provide COBRA coverage of some sort. Now, there are potentially a couple ways to address the COBRA requirements, depending on how plan terms are drafted, such that there may not actually be any benefit to take advantage of during a COBRA coverage period, but still COBRA compliance is still something that needs to be considered. And there are a couple options for addressing COBRA. You could just offer COBRA for the continued testing program, similar to what you do with your other group health benefits. In that case, you could collect premiums. So it's unlikely that anybody is actually going to elect COBRA coverage in that case, because I highly doubt anyone's going to want to pay a premium to participate in an ongoing testing program. You could provide for, instead, automatic continuation during the maximum COBRA period. This may be attractive to employers who find that the expense of sending out COBRA election notices to individuals is onerous. And keep in mind that this is a crowd that's likely going to be broader than the crowd who has elected your major medical coverage. So you would be in a position, if you are offering and requiring election for COBRA participation, you'd be in a position of having to send notices out to, possibly large numbers of individuals who wouldn't normally get COBRA notices, possibly because they haven't elected to enroll in or are not otherwise eligible for other group health benefits offered by the employer. So if you decide to go the automatic continuation route, you don't need to send an election notice, but you can't collect COBRA premiums in that case. So if somebody does, pop up and say, I want a test under this program, then potentially you would have to provide testing for that individual. However, as I said, there could be ways to address this through the drafting of the terms related to the coverage that's being provided. That sort of depends on the guidance that we'll get under the ETS and what might be permissible depending on those guardrails. Next slide. All right, so HIPAA and ACA considerations. So one of the options that we've seen a lot of employers take advantage of when they want to provide testing or vaccines on a broader basis than maybe has been provided to just the group health plan participants, is that they have wrapped these benefits into their EAP program or created a separate special COVID EAP that is limited to testing and or vaccine benefits. The benefit of doing this as an EAP is that if you are not providing significant benefits in the nature of medical care, then it should qualify as an accepted benefit EAP as long as you are not imposing any cost share related to the testing or vaccine. If it does qualify as an accepted benefit, that means that it's exempt from the ACA PHSA mandates. So things like the requirement to cover preventive care services. If it does not qualify as a accepted benefit and you're providing it to a greater number of individuals or a greater pool of individuals than are eligible for group health plan coverage and have actually elected your major medical coverage, then potentially you're in a situation where you've created a group health plan that possibly does not comply with the ACA. There are potential penalties that go along with that, including a per day fine of potentially $110. Now that, this is not currently a huge enforcement priority of the enforcement agencies, but that could change. So we generally try to advise employers that if they are going to broaden the eligibility criteria and provide vaccination and testing on a broader basis than just to individuals enrolled in their major medical plan, that there are some options as we discussed, and we would recommend trying to organize that benefit as a accepted benefit to avoid those ACA compliance issues. If you are providing the benefits purely on-site, so you are only providing them on-site to individuals who come on-site, employees or their dependents, then it would potentially fall under an on-site clinic exception and would be considered an accepted benefit for ACA purposes and also HIPAA privacy. If it's not on-site, if it's instead, for example, an EAP program where you're allowing participants to get testing on-site, but you're also paying for testing or vaccinations that occur off-site, then that would likely be subject to HIPAA privacy and security. So possibly exempt from ACA, but still subject to HIPAA privacy and security. Next slide. All right, so it's subject to HIPAA privacy, and I've seen a couple of questions roll in about sort of the parameters around requesting information about vaccine status and testing status. So if something is considered to be a group health benefit, that group health plan itself is going to be considered a covered entity under HIPAA. And that group health plan for HIPAA privacy and security purposes is considered to be sort of a separate legal entity from the employer. And what that means is that there are some walls between the employer and the health plan. And there are rules about the information that the health plan can provide to the employer without a valid authorization from the participant. So for example, if a group health plan holds information about vaccination status, so group health plan has information about the participants in the group health plan who have received vaccines, the employer cannot, without getting an authorization from participants, go to the group health plan and say, give me a list of everybody who's been vaccinated. That would violate HIPAA. What the employer can do is, if the employer is providing testing, if the employer is sponsoring a group health plan, maintaining a group health plan that's providing testing or vaccines, or that's paying for testing or vaccines, the employer can require employees to provide HIPAA authorizations authorizing the release of information to the employer. That HIPAA authorization can be a condition of employment. So employees who refuse to provide that authorization can be terminated. However, it cannot be a condition of benefits eligibility. So an employer couldn't say to employees, if you don't provide this authorization, we are not going to continue to cover you under our group health plan, or we're not going to continue to pay for your testing. The other possible solution to getting this information is if the employer sets it up such that the group health plan provides the testing, pays for the vaccines, possibly a third party provides vaccine services, and the results of the testing or the proof of the vaccine is given directly to the employee. And then the employee, as a condition of employment, separate from the group health plan, is required to submit those results directly to the employer. So that's basically taking the group health plan out of it so that the group health plan is not the middleman. In that case, you wouldn't necessarily need a signed authorization from the employee. So this, whichever solution an employer decides to implement, whichever route an employer decides to go with respect to this may depend on some of the administrative concerns that the employer has depending on their work population. If it's going to be particularly onerous for employees to go get testing, then provide the results separately to the employer. If there are concerns that that may create delay, may result in a reduced workforce, the employer might want to make it easier for employees by just getting that information directly from the group health plan or the third party administering the vaccines or the testing, in which case probably an authorization is going to be needed. And most likely, if a third party is involved, they're going to require an authorization before they turn anything over to the employer in any case. Next slide. All right, so just a case study, and this involves ERISA and COBRA. So employer hopes to engage a provider to provide vaccines to employees. No charge would be applied for the employee. Employees who do not obtain the vaccination on site would be able to request vouchers to obtain the vaccination from a pharmacy outside of the employer. The employer also offers an annual flu shot program, but has never really thought of that under ERISA terms. So in this case, the employer could create a vaccination EAP, and they could amend their RAT plan to include the vaccination EAP, which could include both the flu shot program and the COVID vaccine program. They would include that as a benefit under their RAT plan. They would then include a brief description of the vaccination EAP in the RAP SPD to satisfy SPD requirements. And they would indicate in that SPD that employees who terminate employment can request a voucher at any time during the 18-month period following termination of employment in order to comply with COBRA. potentially a longer period could apply, and that would need to be addressed in the SPD as well. And then no changes would need to be made to the Form 5500 because the RAP plan already includes an EAP that's available to employees. So as long as you are self-funding and self-administering this EAP, you're not going to have anything different that you need to report in the 5500. So that's just one example of how this could play out. Next slide, please. Okay, and I'm just going to quickly mention incentive programs for obtaining the vaccine because I know we have a number of questions. So it's been a bit of a roller coaster over the past several weeks. After Delta announced the news that they were implementing a surcharge for their group health plan for individuals who are not COVID vaccinated, we had a number of employers contact us who were interested in potentially implementing a similar surcharge or doing some sort of incentive program related to the vaccine. And then, of course, this news came out last week about the potential mandate of the vaccine. And in many cases, employers kind of hit pause on the incentive idea. And I think that there are a lot of questions related to the mandate that, depending on the answer to those questions, it may not be feasible to continue to operate an incentive program related to the COVID vaccine if a mandate is also in place. It may be moot. It may not, offer any benefit to the employer to continue to offer an incentive program if they have to mandate vaccines as a condition of employment. But depending on how this all shakes out with the ETS, if we're in a situation where there are employers who, go the regular testing route for some or a majority of their population rather than mandatory vaccinations, then potentially we could be in a situation where they're still interested in setting up some sort of incentive program to incentivize the vaccine. If you're interested in doing that, there are a number of considerations that should be looked into, should be explored, including HIPAA wellness program requirements that set limits potentially on the size of the incentive, depending on the type of incentive program. There are requirements potentially that the incentive program include the ability to obtain the incentive by satisfying a reasonable alternative standard. So there are a number of requirements that potentially could come into play with respect to incentive programs. And if it looks like it's still feasible to do those type of programs going forward, we just encourage you to consult legal counsel before implementing an incentive program. I think we can go forward to take questions now.
Thanks, Beth. Appreciate that. Sorry, we were on mute here in Cleveland. Thanks so much for all that information. We do have about, looks like about 13 minutes left. We have a ton of questions. We will try to get through at least some of these, and we're trying to get through the ones that are probably applicable to more people who are on the phone. So please forgive us if we don't get to your question. We will do the very best that we can with the time that we have left. One of the questions that was raised was asking about, I had recommended getting a better handle on whether your workforce is actually vaccinated at this point and ways that you can go about doing that. And one person asked whether or not those inquiries or surveys have to be done anonymously. The answer to that is no. You have the option of doing it anonymously, but you can, ask employees specifically to identify themselves, fill out a form, fill out a survey, put their name on it, indicating whether or not they are vaccinated. You can ask them for proof of vaccination. The key point is, given privacy concerns, medical information, et cetera, obviously you should not post a list of, here are all the employees who are vaccinated. That information should be kept in a private, medical confidential file and be shared only on a need-to-know basis. But oftentimes it's important to know who's vaccinated and who's not, because that may impact a quarantine situation in terms of, somebody who may have been exposed, whether or not they have to quarantine potentially can depend on whether or not they have vaccinated status. So you can ask those questions, that's permissible. The key thing is, do not ask the follow-up question. Somebody responds to the survey, they say, no, I'm not vaccinated. You should not then be saying to them, why not? That is potentially an ADA violation. So you should not be asking that question. If you're implementing a policy that says everybody's got to be vaccinated, you'll want to communicate to your employees if for whatever reason you cannot be vaccinated due to a disability or a religious objection, please get in touch with, fill in the blank in the HR department, and then that person will go through the accommodation process with them. So hopefully that answers that question. Another question that I had was regarding clients dealing with religious objections to vaccination and how they are dealing with that. I'll give you a quick non-law review article level review of sort of religious accommodations, which people have largely not had to deal with, most of us, even in our entire careers, but now that's becoming something we're dealing with all the time. So if someone has a sincerely held religious belief regarding vaccination, that can be something that provides for essentially an exemption from a mandatory vaccination requirement. A lot of people get wrapped around the axle as to what is a sincerely held religious belief, and it's very complicated to figure out whether something is sincerely held or not. It does not have to be something that is part of an established religion. The person does not need to have a letter from their rabbi, their minister, their priest, confirming that this is a sincerely held religious belief. Those are not the standards. So a lot of times, people are sort of skipping over the sincerely held part of, is this a sincerely held religious belief? And just skipping ahead to sort of the accommodation part of the process to say, okay, can we accommodate this person's inability to get vaccinated? Let's just assume that they have a religious objection that is valid. And then is it an undue burden for us to accommodate this religious objection? And the standard for undue burden when it comes to a religious objection is actually pretty low. There's a Supreme Court case on this from 15, 20 years ago, but it's a de minimis standard, which is a very low legal standard. In terms of saying this is an undue burden, and courts tend to be fairly deferential on issues that relate to workplace safety. So that's just a brief overview on religious accommodations. It is complicated, but just wanted to kind of give you an overview on that. The other thing I will warn you about is what I've just said to you is the federal standard that's applied to religious accommodations. There are states that have different standards. For example, in New York, the standard is higher. So you do have to think through both what is the applicable standard at the federal level, as well as any applicable state level on those types of questions. I will do one more, and then I'll see if Matt and Beth may have some questions that they want to respond to or address. Somebody asked the question about what if you have a workforce that is 100% remote? It's going to be 100% remote forever. What is going to happen with respect to those workers? As Matt alluded to, first of all, we don't have the written guidance yet, but it is possible, based on sort of the broad brush outlines for the government contractor status, that whatever the rules are with respect to services that are being provided pursuant to an applicable covered government contract or subcontract, that those rules may apply to anyone in any location who is providing those services. So even though your workforce may be 100% remote, if you fall into some of those government contracts that are covered, that those rules may apply to you. With respect to the OSHA standard, which again we don't have, but we know from past information from OSHA. They do not tend to enforce or go after people who are working in their homes. They don't do inspections there. So it is possible that the 100% remote worker will not be covered by whatever it is that OSHA puts out in that regard. So hopefully that answers that question. Matt, I think you had a question that you wanted to answer.
Certainly, from the contracting side, we had a question where it was, would the mandate for government contractors apply regardless of the size of the company that may be holding the particular contract? Again, for the first question or consideration is what type of contract do you have? And if you have a contract or subcontract that falls within the covered categories under the executive order, there is no minimum employee threshold for your company to be covered. So I guess the answer to that question would be yes. If you hold a covered contract, you would most likely need to comply with the mandates regardless of the number of employees you have. Another question from a contracting angle was, whether construction contracts that are covered by federal affirmative action requirements would also be subject to the pending COVID-19 guidelines. And again, the answer to that question is most likely yes, because the executive order does include procurement contracts for construction as one of the particular types of government contracts that would be covered and subject to the guidelines and any requirements.
Okay, I had a couple more questions, and then Beth, I'll see if you have some questions that you want to answer. Someone asked the question of, regardless of whether their organization is covered by whatever comes out from OSHA or as a government contractor, let's assume they're not covered, can they still require vaccination of their employees? The answer to that, based on what we're seeing from the courts, is yes. Again, you do not have to provide a testing alternative. They asked that question as well. If you do have a mandatory vax, you do not have to have the testing alternative. You do have to work through the issues of whether or not somebody can meet the vaccination requirement. If they have a disability which does not allow them to be vaccinated, or if they have a religious objection, you do need to go through that process to see if an accommodation is available. And then obviously, there's sort of the business consideration of, what would the impact be on your workforce? Well, you have a lot of people who drop out, quit, refuse, what have you. Operationally, can you weather that storm? But yes, from a legal perspective, you can require your employees to be vaccinated. Someone asked the question of, why are there still mask mandates when people are vaccinated? Again, I'm not an epidemiologist. Let me just be clear about that. Mask mandates, as I understand it, generally to the extent that those are applicable, they are there because even if you're vaccinated, you can still be a carrier. And so that's why there are still some masking requirements, or why some employers are still requiring people to be masked if they're interacting with other individuals in the workplace, et cetera. So wanted to put that out there. Beth, did you have some questions that you wanted to answer?
I do, yeah. Thanks. So we did get a question about asking for clarification as to whether new testing programs would be for those employees who are not part of the company's medical plan and opt for continual testing rather than receiving the vaccination. So first off, I just want to note that as far as opting for continual testing instead of vaccination, I think we still don't know whether that will be an option, and we need to wait for the ETS to determine whether it will be, truly an option that can be left to the employee, or whether there will be stricter requirements in place with respect to employers having to mandate, except for perhaps limited groups of employees who satisfy specific exemptions. But as far as any new testing program that results from this, I think that it likely is going to be, to the extent that an employer is doing weekly testing for workplace safety or fit for work purposes, this is likely going to be something that should be looked at as a separate benefit plan outside of your major medical plan. For employers who self-insure, it's not going to be a huge issue because you're paying for the ultimate testing either way, either under the medical or under the workplace safety initiative. But for employers who have fully insured plans, it's possible that your insurer may not even agree to pay claims that are related to testing for workplace safety purposes rather than for, diagnosis of potential COVID illness based on symptoms that have arisen. So I think the best way to be thinking about this now is that to the extent you're going to have to do broad-based testing of a large segment of your population, potentially including individuals who are not covered under your group health plan, that probably is going to be looked at as a separate benefit program. You might have additional, you might have more leeway if you self-insure, but that's something that will need to be considered based on your numbers and how many people are enrolled in your plan. Another question that keeps on popping up that I believe I saw on the question thread was related to the validity of these vaccination cards. And if there are questions about the proof of vaccine that's been submitted by an employee. In general, like I said, things not to do, don't just go to your group health plan and say, Bob submitted this vaccine card. It looks kind of fake to me. Can you tell me if Bob, submitted a claim for coverage of a vaccine? Can we tell from his claim records if he actually received a vaccine? Don't do that. What you can potentially do, as I noted, is if you're concerned about the issue of fraudulent vaccine cards or fraudulent vaccination proof, you can request the employees provide that HIPAA authorization, which will then give you the ability to actually check their health records to determine if they did in fact get the vaccine, if it lines up with the proof that they've given you. There are specific requirements that go into HIPAA authorization, so we do recommend that you consult with counsel in crafting those. And I would be careful about if you think it's going to be an issue, maybe setting up expectations that you're going to require those HIPAA authorizations broadly of all employees going into this program, rather than sort of picking people out piecemeal and saying, hey, we need a HIPAA authorization from you, because you don't want to get into a situation where you're potentially inviting discrimination claims.
Great, those are great topics. And just one caveat I want to say before we wrap this up, I did answer the question about whether mandatory vax is legal, and you can do that. Be aware the state of Montana would not permit you to do that if you have employees in Montana. Please keep that in mind, and be aware that states are passing restrictions regarding what will be permissible in their state. So you should check the state law that is applicable to your jurisdiction. With that, I know there are still some additional questions, some of which are really individual and specific to your situation, and I'm sorry that we did not get to those. Just so that you know, we will be sending, again, the presentation, today's recorded session, as well as the PowerPoint to everybody who registered within 1 to 2 business days. So please look for your email. Those should be coming unless it gets blocked by your spam blocker. If you do have questions that we were unable to get to today, please email or call your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, please contact any one of us, and we'll be happy to discuss options with you to address your needs. Thank you so much for attending. We hope this was helpful. Have a great day.